All right. Good afternoon, everyone. Thank you so much for joining us. My name is Will Creeley. I'm the legal director for the Foundation for Individual Rights and Expression, a nonpartisan nonprofit dedicated to defending freedom of expression nationwide. But today, I join you in my capacity as the co-chair of the Education Committee of the American Bar Association's Administrative Law and Regulatory Practice session. So thank you for joining us for reviewing the Department of Education's proposed Title IX regulations. And I should note at the outset that the views expressed by me, the presenters, and the audience members are those of the individuals and do not reflect the positions of the American Bar Association or the section of administrative law. The chat feature here is available to facilitate discussion and should be used with discretion so that all participants have an opportunity to have their questions heard. All right, so let's get started. This year, Title IX, the federal anti-discrimination law that provides, and I quote, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." Well, this year, Title IX celebrates its 50th anniversary. In a birthday present for me and my fellow members of the admin law section, the Department of Education is celebrating by proposing new Title IX regulations that will change how educational institutions nationwide respond to allegations of sex discrimination and more besides. The proposed regulations follow hot on the heels of the regs introduced and implemented under former Secretary of Education Betsy DeVos in August 2020. Amidst a flurry of litigation, the new rules would once again recalibrate institutional obligations to both reporting victims and students accused of sexual misconduct. And once again, the proposed regulations have been met with praise and criticism from advocates and attorneys alike. We will parse some of that today. This is a topic of interest to many, not just the 157 of you that are joining us today, but more than 235,000 comments were sent to the department about its proposed regulations during the 60-day comment period, which closed mid-September. So as we wait for the department to review the comments and finalize the regulations, I wanted to reconvene the same expert panel we brought together back in July of 2020. It feels like 4,000 years ago. It was just 2 years ago. At that time, we were discussing the Trump-DeVos regulations. Today, we'll discuss the Biden-Cardona regulations. We want to take a closer look at what's changed, what hasn't, and why. So let me start off with some introductions. First of all, Laura L. Dunn is a nationally recognized victim rights attorney, campus sexual assault expert, and award-winning social entrepreneur who's been featured in Forbes, BuzzFeed, National Law Journal, and many more publications. Dunn has regularly worked with presidential administrations, the U.S. Department of Education, and others on campus safety legislation and policy, including Clery Act and Title IX regulation guidance. Dunn is also an adjunct at Maryland Law, a published legal scholar, and an accomplished litigator. She has received several national and international awards and recognitions, including the 2017 Special Courage Award from the U.S. Department of Justice's Office for Victims of Crime, and a 2018 TED Fellowship, among others. Please welcome Laura Dunn. Patricia Hamill is the co-chair of the Title IX and Campus Discipline Practice at the Philadelphia-based law firm Conrad O'Brien, PC. She's a highly regarded and Chambers-ranked attorney who's represented hundreds of students and faculty members in disciplinary matters or related litigation at colleges and universities around the country. Patricia has also represented students in lawsuits against the universities for breach of contract, violation of Title IX or other civil rights statutes, and tort liability on the basis that colleges' investigation and adjudication procedures failed to ensure her clients' fundamental due process rights, discriminated against them on the basis of sex, and breached the school's contractual obligations. Patricia is often sought out by groups and institutions for her opinion on how to work within the framework of the changing federal laws and guidance. She was invited to testify before the United States Senate Committee on Health, Education, Labor, and Pensions at the full committee hearing on reauthorizing the Higher Education Act, addressing campus sexual assault, and ensuring student safety and rights in Washington, D.C. Recently, Patricia, with others, submitted comments in response to these regulations that we'll be discussing today, advocating and expressing concern about the proposed revocation of rights that, in her experience, have led to greater fairness and transparency in Title IX proceedings in recent years. So welcome, Patricia. Last but not least, Joseph Storch is the Senior Director of Compliance and Innovation Solutions for Grand River Solutions. In that role, he advises clients on best practices in Clery Act and Title IX compliance and works to develop new products, trainings, and resources to assist clients in their compliance, response, and prevention efforts. Joe has provided live training to tens of thousands of higher education professionals in 30 U.S. states, furnishes technical guidance to numerous education institutions, organizations, and associations, and has twice served as an expert witness before the U.S. Senate, Armed Services in 2019, and Health, Education, Labor, and Pensions in 2016. Previously, Joe served as the Associate Counsel in the SUNY Office of General Counsel and Chair of the Student Affairs Practice Group, where he founded the Center for Advanced Research in Reducing the Impact of Violence in Education, the ARRIVE Center, and served as Principal Investigator on more than $20 million in grants and external funding. He founded and oversaw the SUNY Student Conduct Initiative, which offers compliance and best practice training annually to thousands of higher education professionals engaged in response to violence and conduct violations. And he served 4 years as executive editor of the Student Affairs Compliance Report Analysis. He's on the editorial board of the Journal of College and University Law. He's the author of more than 75 articles and book chapters and law reviews, practitioner journals, and popular media, most centered around campus safety or copyright law. Thank you, folks. I know that's a lot of words, but I want to establish the bona fides of you three. So now with those boxes checked, let's get into it. So first of all, Laura, if I may, let's start with you. So what has changed since the last time we spoke in July 2020? Perhaps for folks who are listening, may have some idea of the overturning or the tumult in the area. Perhaps you could give us a general overview if that works.
Yeah, I'm going to go way before 2020 and talk about what the regulations used to look like. They came out around 1976, I believe, and were not changed until 2020. So we had a very long period where, as far as the Title IX regs, there were several topics, but for the issue of what a lot of us will be discussing today, campus sexual misconduct, the procedures on campus, there was all of one sentence. And that was under 34 CFR 106.8, at that point, subpart B, that talked about a prompt and equitable grievance process for students and employees. And that really is where all the guidance under the Obama era came from, of what does it mean to be prompt? What does it mean to be equitable? What should these grievance procedures even look like? And the regulations were sparse, hence the need for guidance. So a lot of people criticize the guidance, but the alternative was no information really for schools. So guidance materials had come out 2001, the revised sexual harassment guidance. We had the 2011 Dear Colleague letter that got a lot of attention, and the 2014 guidance as well. So a lot of that has been criticized. Obviously, coming into 2017, the Trump administration started rescinding guidance. They left the 2001 revised guidance in place because it had gone through notice and comment, but removed all the other guidance materials. And then we had, in 2020, the Trump regulations. And what was surprising is that we went from one sentence to what were over 2,000 pages of preamble together with changed regulations under the Trump administration. So that was a really massive shift in understanding. And schools had a very short period of time, if people will remember, in between dealing with the pandemic, to read all those 2,000 pages, change all their policies, and then gear up for the next school year. And a lot of advocates also had to work through it and try to understand the changing landscape. So we've had those regulations in place, obviously, about 2 years or so. And now we have the Biden administration regulations, the proposed regulations. And I am surprised that they still remain at a high volume. There is a lot of materials for those who have read the proposed rules or contributed to the comment period. It is much more significant than I thought it was going to be, going from one sentence to thousands of pages. We still have thousands of pages. So that is kind of where we are, is just a high volume of regulation going into a variety of school settings. Any school that's receiving federal funding for their programs, and even non-schools that receive federal funding to have educational programs and activities, are all now bound by a lot of regulation.
Yeah, I remember 2,000 pages. The last time we spoke, Laura, we did focus on the short timeline and the extensive regulatory obligations imposed. Joe, if I may turn to you, since 2011, I think we've seen a pendulum swing. Can you describe, as someone who now works in consulting, but previously was in a general counsel office, what this means for institutions, and what's your sense of the change in such a short period of time indicates?
Sure, thanks, Will. And building on what Laura said, in addition to the regulations being pretty static from the 1970s until just a few years ago, we actually saw interpretations by presidential administrations looking pretty much the same. Reagan and Bush 1 and Clinton and Bush 2 and the beginning of Obama really looked very much the same. And it was really in the last 11 years, April 4th of 2011, the Department of Education issued a Dear Colleague letter. Among the hundreds of Dear Colleague letters that they will issue, this became known as the Dear Colleague letter, and everybody was aware of it, took note of it. And for many people, they thought, this is really just kind of summarizing a lot of things from a bunch of different guidance documents and program reviews, putting them in one place. Other people thought, this is really a significant expansion or extension of some of the things that we had seen in the 2001 guidance that Laura referenced. There were different views on it. But what we have seen in the 11 years since then is more and more significant swings than in the prior 40 years of Title IX. So the Obama administration issued that and continuing guidance on that, maybe some extensions in 2014 and 2017, as Laura said, that was all pulled back, and regulations were issued that really were seen as swinging in another direction. The Biden administration, the moment those regulations came, or the Biden candidacy, the moment those regulations came out, said that he would oppose it. And indeed, in the first year or so of his administration, there was some guidance and some pullback, and now the regulations. And what is a challenge to me in helping students understand this, helping faculty and staff understand this, and helping colleges and universities implement this, and the little K-12 implement this, is that the swinging pendulum is good for nobody. And that swinging pendulum has gotten heavier and swings further. And a lot of folks here probably, familiar with the National Labor Relations Group, and we know you can tell how the NLRB is going to rule on something by looking at which party is in the White House. And I'm afraid to say that I think we've entered a period where we could tell how Title IX is going to be interpreted by looking at who is in the White House. And that is good for nobody. So what we hope out of the new administration, out of the new regulations, is not necessarily that they're going to stop the pendulum. I think that train might have left the station. But can we take weight off the pendulum? So either it slows or it doesn't swing so heavily in both directions. Because as I like to say, a pendulum that swings so wildly is impossible for students to grab a hold of. And when we talk about such a critical civil rights, the most critical 37 words that the Congress has ever written regarding equality on the basis of sex or gender, it is a shame that how it is interpreted and whether it applies really depends on which party hangs their shingle on the outside of the White House.
Thanks, Joe. That's very helpful. Patricia, turning to you, as Joe describes it, this pendulum swinging. Well, what is the force behind that pendulum? Joe noted that the 2011 Dear Colleague letter, one of many, but the Dear Colleague letter, as Joe put it, prompted a great deal of controversy and criticism. What does it look like for you, for a litigator who represents students and faculty?
Sure. And I do mostly represent responding students, though not exclusively. And I agree with Laura and Joe, the fact that, it's like this ping pong that's going on in this setting doesn't help anyone. And most likely universities are the ones, or K through 12, that are feeling the biggest brunt, because students pass through eventually and move on into the world, but the institution is stuck with whatever the policies are that they've had to put in place. And I think one of the things that we haven't touched on as much, and Laura and Joe not as much in their comments, there was a tremendous amount of litigation that came out of or in the wake of the 2011 Dear Colleague letter, much of it from accused students who felt that they had been treated unfairly in the processes that colleges and universities had put in place in response to the 2011 Dear Colleague letter. So it's not just a matter of sort of plucking regulations out of the air. There was an environment, a very contentious and active litigation environment that was fueling a lot of the pushback to the legislation through these Dear Colleague letters, or at least the 2011. So I think that's a big piece of what and I don't call him Trump or Biden. I'm apolitical. I come at this as a lawyer who's looking for fair processes, but I think a big part of what went into the 2020 regulations was responding to a lot of the litigation that had been filed, frankly, by responding students who felt that the processes were unfair. I do note that there were 4 legal challenges to the lawfulness of the 2020 regulations, and they were largely unsuccessful, except for one little tiny provision about excluding statements made outside of the hearing process that everybody thought was goofy anyway. So they have been vetted, and the same thing's going to happen with the whatever they're going to be 2023 regulations. You're going to now have a whole nother set of legal challenges, and this is sort of like musical chairs, and it's like, where are we going to land? And hopefully it's somewhere closer to the middle for everybody involved.
Well, that's useful, Patricia. That gives us a sense of where we are now and how we got here. And I should note, just as a matter of full disclosure, my organization, FIRE, participated as an intervening party in some of those suits. Again, I'm here in my capacity as co-chair of the Education Committee. I wanted to see if Laura, you might react to Patricia's characterization of the litigation before we delve into the nitty-gritty of what's changed from the 2020 to the current proposed regulations. To see if, Joe or Laura, you have thoughts on why this pendulum is swinging and what, if any, consequences there might be, both for institutions, but also really for students and the students you work with, Laura.
Yeah, prior to the Dear Colleague letter of 2011, it was the experience of survivors such as myself and others who have now become lawyers and advocates in the space that it felt like these kangaroo courts, these campus hearings were stacked in a specific direction, right? We know that there is some level of gender bias when it comes to addressing sexual violence. Survivors often thought of as women, perpetrators often thought of as men. And then within that, layers of victim blaming. What was she wearing? What was she drinking? There's a whole history here around that. And so when the Dear Colleague letter came out for survivors, it was kind of this moment of, you will have equal access to this process. You will have the same rights as those accused. It's not that the accused has rights and you don't, and you're just a witness as you are in like criminal proceedings. So it was a big moment, and there was a lot of blowback and pushback. I like to think that a lot of the challenges for schools was because schools were already not giving due process, but no one complained before because they weren't getting found responsible. But now that they were being found responsible, they said, well, actually, now we need a process too. And so I agree that the 2020 regs really did build in elements of kind of what we generally colloquially will call due process, both for public and private schools. Was that appropriate to do under Title IX? I am of the mindset it is not. Title IX is meant to protect those who are experiencing discrimination, not people who are committing or potentially accused of committing the discrimination. So we see with the Biden regulations that there's been a readjustment, that focus on kind of a due process is still there. And that bluntly surprised me. I did not expect the proposed regulations that I saw. I thought the administration would go more narrowly and just put guardrails into place and really allow schools the autonomy that they had enjoyed for decades. Because even though I'm critical of schools, as are a lot of due process attorneys like Patricia, I think we both agree that schools do not do a great job at handling these processes for any students involved, no matter what their position. But what I saw was like nitpicky, detailed regulations that made a lot of assumptions structurally about the institutions that have to implement them. And I believe that there is going to be another wave of litigation. I don't think that this current administration has thought through all the implications of having such specific regulations. The Trump administration did that to, firmly grab the wheel and shift it one direction. And unfortunately, the same thing is now being done where we're having hyper-specific regulations rather than giving schools back some level of autonomy as long as there is some notice. Does it have to be a certain set of days? Leave that to the school. But that's where we are. And yes, I think litigation is coming yet again.
Thanks, Laura. Yeah, you could kind of hear it off in the background. It is getting louder. Joe, I wanted to see if you wanted to respond to that before we dive down into kind of the substance of what the proposed changes would entail.
Yeah, and I would agree with Laura that the Biden administration is re-mowing a field in a stadium built by the Trump administration. I think, to Laura's point, well, we did 40 years of one sentence and guidance. My sense is that the horse has left that barn, as they would say, and we're never going back to that. So whether or not that would have been better or not, my sense is that had the Biden administration just select all, cut, and then paste in a couple of sentences, it would have been overturned by courts right away. So from the admin law perspective, like, this is the stadium we're going to be playing in for the rest of our natural lives, those of us who are here on the panel and probably many more generations to come. I think that one of the challenges that I always push back a little on is sort of painting colleges and universities with this broad brush. Were there institutions that were not appropriately addressing the needs of those who had experienced sexual harassment, sexual interpersonal violence? Absolutely. Were there institutions that played a little bit fast and loose with some of the processes and did not provide those who were accused with the rights that either they had under the Constitution as determined by their circuit or their state Supreme Court, or under the institution's own policy? Absolutely. My sense, though, is that there is not a sector of society that has done well in this, right? We've seen it in the entertainment industry and the TV industry, and we've seen it in politics, and we've seen it in sports, and we've seen it in any nook and cranny. You could see it just this week in another major sporting league that was credibly accused. And so within that, there were institutions that are doing and have done and will do an incredible job. And my sense, and what I've built my career on, is that they have professionalized the role of addressing sexual and interpersonal violence, sexual harassment, and the like. So if you look at all the work I do with campuses, it is about treating this in the highest level of profession, having policies that are clear and plain language that students can understand, that employees can understand, and applying those in an equitable way, trying to reduce the biases we all carry with each other, trying to reduce the errors that we take when we are overloaded and can't handle this case because we have 9 others and the like. We are not there yet. Not that any other industry is there yet, but certainly I think higher education should be the leaders in this and should serve as a model. I'm not sure that the regulatory approach is what gets us there, but what it has done is given a hook, frankly, to those who provide the kind of work I do, the kind of trainings, my colleagues and I do, and, to try to really push the industry to professionalize this work. Because if you just handle it as you would other cases, a student drinking in the residence hall or somebody screaming in the halls, it's not the same thing. It doesn't have the same ramifications for all the parties involved.
Thank you, Joe. This is why I feel like this is such a terrific panel. I think we've got 3 distinct perspectives represented here. And let's dive in now. We've talked about a bit of the 30,000-foot view, the historical view, some of the political shifts, and let's talk about exactly what changes in the proposed regulations from the 2020 regulations. Patricia, if I may start with you, there are lots of changes. It's a big document. I don't expect you to be exhaustive, but if you could talk to us perhaps about the ones you see as most substantial or most noteworthy for our audience here today, and then later on we'll discuss which you like and which you think are misguided. But just what are the big ticket items here?
Yeah, I would say for anybody who is in the student, looking at the investigation adjudication process, we're now going back or potentially back to a place where there will be no live hearings. It's okay not to have live hearings in the grievance process if a college or university chooses not to. And again, I focus on higher ed. I know, there's a K through 12 aspect as well.
Patricia, when you say live hearings, just for our yep. Sure everybody's clear on what exactly that means. What does that describe?
Sure. So under the 2020 regulations, if a complaint goes through the formal grievance process and it's not otherwise dismissed or informally resolved, at the end of this investigation, commenting on evidence and whatnot, there will be a hearing that will either include a panel, a hearing officer, but some level of an independent hearing of the evidence. The parties involved, the complaining student, the responding student, will be provided advisors or can have advisors who would be attorneys or could be appointed by the school by somebody who's already been trained as an advisor. It allows for the current regulations require that there be advisor cross-examination of the other party as well as witnesses. Under the current proposed regulations, universities, colleges could still go ahead and have those live hearings, and they could, go all the way to the point where they're doing what's currently in place in the 2020 regulations, but they also have the discretion to dial it back, to not have a live hearing, but instead to have what I would call a single investigator model where one person, it could be the same person. The Title IX coordinator could also be the investigator, could also be a person at the end of the day who's going to make a decision about whether a student should be found responsible or not. And there's a process for gathering the evidence and whatnot. I think but that to me, for anybody who's representing students through the formal grievance processes, the fact that live hearings are no longer required is a big deal.
Yeah.
I think the fact that you can have a single person play all these roles is a recipe for trouble, but that's a substantive change. There's a more limited access to evidence, I think, than under the current regulations. There's and the one other place I would say there's a lot of other changes, but I'm going to say one more thing and stop there. But the other, and it's sort of a subtle, but it's a very important, on appeal now, the issue that you'd have to raise, whether there were procedural errors or new evidence or whatever, you'd have to show that it would have basically changed the outcome had this been different. And currently it's more of a materiality, or it could have affected, and appeals are already very difficult to succeed on. I think they're going to be impossible going forward. Those are the big ones. There's lots of others, but
I appreciate it. It's not an easy task to summarize here. I'm turning now to Laura. Laura, what strikes you as most noteworthy?
Well, I'm going to give a comment to what Patricia was talking about for a moment quick about the single investigator model, because I think she's being very polite. And Patricia, correct me if I'm wrong, I think we both hate that model. Like, we as advocates do not believe that this is the correct model for schools to use, period. And since 2016, when I worked on the ABA criminal justice section task force on college due process, people kept saying, well, advocates, survivors want this. Which ones? I have never met them since 2016, and I've been earnestly looking as someone who does national level policy work. I actually think it's the schools that want this process because it's low resource. And is that the best reason for that policy? I would argue not. I've definitely had horrible cases, one in which the investigator was biased. We appealed the biased. The school agreed it was biased and then remanded it back to the biased investigator to fix their bias because it was a single investigator model. And the single investigator model, looking back at the White House task force efforts under the Obama administration, arose there. It was highlighted by the Obama administration, and I think it was being implemented by the University of California system. But I have yet to meet any advocate for those accused, for those who are reporting victimization, who likes it. And yet now we're going to have it codified in regulation, which I'm very alarmed about. So that's a negative, and there's plenty of comments that have been submitted on that topic. Some other changes that are worth highlighting. Something that was kept from the Trump era regulations that I do not in any way agree with is the framework around interim suspensions. So the Trump administration called them emergency removals, which to me sounds like hyperbole. Like, they've been called interim suspensions since the beginning of time. Schools have done them all the time. And it's meant to create a safe campus. Schools have tons of discretion to keep their campuses safe. And yet the 2020 regulations elevated it to this emergency status that had immediate threats. And what I saw, practically speaking, was clients who had been hit in the face, choked, bitten all over their body, including their genitals, and their offenders who committed this physical damage to their bodies were allowed to remain on campus without any interim suspension because they did not feel that the high bar of immediate threat was met. And you can only imagine, if you're that survivor who's suffered that physical violence on top of any sexual violence, the fear that you would have remaining on campus with that individual. Several of my clients left their campuses. Several of them have been hospitalized. Like, it was a high bar that no school was willing to argue that it had met, except for one brave K-12 school. And there was immediately a lawsuit, and the school won and said there was a reason for it in a much less violent situation. So for some reason, the Biden administration has kept this language, has kept a very high standard. And I don't think that's appropriate. Again, I believe regulations are guide rails. They are not the nitpicky of the policy that schools should be implementing. Schools need to be able to have the right to do that and need to consider their, not just federal law, but literally state law. You know, what is due process in the state where this is occurring? So that's one of the other issues, and I can pause there and let
Yeah,
others comment.
Well, that's a great thing about this. I know each of you, we could do an hour with each of you. So, Joe, I know you're itching to get in on this. Joe, what are the big ticket items? And then, of course, if you want to respond to anything Patricia and Laura have said, feel free.
Sure. Well, I want to talk about something completely different,
Please.
which is the way that the administrative regulations treat sexual orientation and gender identity. I am old enough to remember a time 7, 8, 9 years ago where this would have been unthinkable. The department says in black letter in the regulatory language that sex as interpreted under Title IX of the Education Amendments of 1972 also prohibits discrimination on the basis of sexual orientation and gender identity. I was privileged earlier in my career to work on legislation in New York, and when that was passed in 2015, it said for the first time in our nation's history a law saying that the rules around sexual violence, sexual harassment, sexual misconduct would apply equally regardless of the sex, gender identity or expression or sexual orientation. That was the first time in history. So we're not talking about something that folks have been chewing on since the 1960s. We were talking about something that is very historical. Now that is being challenged. We all know about the Title VII case of Bostock and related cases where the Supreme Court said that for Title VII purposes, sex is interpreted to also include sexual orientation and gender identity, because to discriminate on that is to discriminate on the basis of sex. If a female is fired because she likes another female, but would not have been fired if she was a male who liked that same female, that is in fact discrimination on the basis of sex. And for those of us who do Title IX work, we said, okay, obviously Bostock is going to apply because there's so much less Title IX litigation than Title VII that Title IX has always borrowed from Title VII. And yet, this has been a very controversial area where a number of state attorneys general have written to the department, have threatened to sue it based on applying the same standard, basically select all, copy, and paste it into Title IX, as the Supreme Court said in a Title VII case, ye only 2 years ago. So it's surprising in the historic nature of it, in that when any of us on this panel were in college, this kind of equitable treatment on the basis of sexual orientation or gender identity would have been unimaginable. And yet it's unsurprising in light of the Supreme Court's very, very recent 6-3 decision supporting this. So that is something that's historic. It's going to be a controversial area. In fact, the vast majority of the 200,000 comments that Will referenced earlier have been about this single issue, which Patricia and Laura and I think would not have imagined would have been the lead issue, right? Single investigator, hearings, live hearings, cross-examination. These are the things that folks have been talking about, and yet this has been the lead issue. But I think it is a fairly historic thing when you pause and think about it.
Yeah, thanks, Joe. I appreciate that, because I don't want to bury the lead here. And I'm glad you brought that up. And so I was going to ask what your sense of the volume of comments dealing specifically with that question would have been, and you indicated that you think it's quite a bit. What do you think, if I may just follow up with you on that particular point, what do you think the practical outcome for schools will be for your clients, for the schools you consult with? Let's say the regulation as proposed goes into effect. What if any will be the real consequence in terms of schools' policies and procedures?
Yeah, I think for the vast majority of institutions, it will make no change because they have already been addressing sexual orientation and gender identity as discrimination on the basis of sex, whether under Title IX or under allied policies. I think there are some institutions which, for religious reasons, have some opposition to that, and they can use the fairly liberal applied exception to Title IX for religious institutions that the Department of Education authorizes. And then maybe there's a small group, between those Venn diagrams that are not currently addressing it, but yet might not want to use the religious exemption. But I think in practice, it might make little difference. But to that student who is a member of the LGBTQIA plus community, to that student who has experienced some harm recently or over the course of their education to that student, and we all know them, who was slammed into the lockers, who was beaten up, who was called horrific names, who was subjected to harassment and abuse in their home environment, in their school environment, and the like. The fact that the federal government wrote it down, I think will have some meaning. I can't speak for them. I can't put myself in their shoes, but I would imagine it would have some meaning to them beyond just, well, it's in the school policy, which could always change.
Sure. Thanks, Joe. That's helpful and useful. And I see the folks asking questions. Please keep them coming. We will make sure we have time for all of them. But before we turn to the excellent questions being submitted by those in the audience, I want to ask Patricia, you've given us some sense of what you're concerned about, I think, particularly with regard to the hearings and the single investigator model. What do you think is helpful here? What looks like an improvement? What looks to you like fine tuning if we accept the kind of granular level of revision here as being just a given, given, as Joe says, what we've kind of discussed, this is now the arena we're playing in. This is the path dependent outcome that we've had where there is going to be this kind of micromanagement. What looks helpful to you? What were you pleasantly surprised by, if anything, in the proposed new regulations?
I wouldn't say I was pleasantly surprised by anything. that would be an overstatement. However, I'm happy to see that informal resolutions are still, very much an option and are encouraged to the extent that they are enshrined in the proposed regulations, because I think some of these issues can be resolved informally, and I'd like to see that. Some of the foundational aspects of fairness, written notice of allegations, those sorts of things. So I think that's good. Advisors can accompany students through every part of the process. That's a good thing. How much they can be involved, obviously, is going to be a big question. I do think that some of the changes that were made in the definition of sexual harassment and some other aspects of the jurisdictional elements of the proposed regs may eliminate what has come up since the 2020 regs were put in place, which is sort of a two-track system where colleges and universities felt, if you didn't meet these jurisdictional requirements for a Title IX, and just for example, things that might have occurred off campus or in an overseas program would oftentimes be shuttled into a standard student conduct process, where frankly, the repercussions for the students involved were just as great as they would be for a matter going through Title IX, but for people, responding students oftentimes had fewer rights in those processes. I also think it leads to a lot of confusion. So I'm happy to see that it appears to be an effort to eliminate that two-track system. Those are the main points I think that I think are helpful.
Yeah, thanks, Patricia. Laura, same question to you, if I may. Is there anything here that caught your eye as being a positive outcome or a positive proposal? Maybe something that removed from the pendulum, something that both Republican administrations and Democratic administrations might agree on, and thus removed from the board, so to speak.
Well, you're setting a high bar. I will see if I can get one that may overlap. I was pleasantly surprised to see that for minor students that they could have a representative. And I, as a victims' rights advocate, am going to have a lot of fun with that. Because unfortunately in K through 12 settings, what we saw a lot is that when these incidents were happening without any notice to parents, without any information about their rights or options, they would immediately isolate and sometimes pressure very young children to make very big decisions.
To be clear, you mean students reporting victimization K-12 would be they were just on their own in that way?
Yes. I have several lawsuits against the Charlotte Mecklenburg School District as just one example of a school that systematically would not provide notice to parents when they were alerted about sexual violence, would not give information about a survivor having a right to an advisor of choice or anything else about the Title IX process at all, but would immediately isolate, pressure, sometimes threaten disciplinary action. If you report and we don't find a sexual assault happen, well, you're in trouble for consensual sex on campus. Like, very serious things have been happening at the K through 12 level, which has been neglected in this whole Title IX conversation we've been having the last couple of years. So I'm happy to see that minors can have representatives so that they can have someone physically present and involved in those conversations. But the other issue that Patricia referenced is off-campus incidents. The Trump era regulations were not aligned with some circuit court decisions under Title IX, such as Farmer versus Kansas State University, that said even if an incident happened off campus, if there's an ongoing hostile environment, which is the standard that we use for these civil rights claims, that there is an ongoing obligation to address it at the campus level. And the Trump administration said if it happened off campus, kick it out of Title IX, period. And that was a very harsh rule that really had a lot of consequences, because as Patricia mentioned, it wasn't just the accused students who had less rights in these normal disciplinary processes. Complainants were completely excluded and had no ability to know what was happening or to be involved in those proceedings. So I'm glad that that has been fixed to match case law.
Well, it was a high bar, Laura, but you met it. I appreciate it. Joe, let's flip this around a little bit, and then we want to get to some of these good questions that are coming in. Joe, what in these regulations really disappointed you, or what strikes you as the wrong track? If you had a concern, what might it be here?
Sure. I hope I have an opportunity to talk about some of the things I like, because they're different as well.
All right, let's do a twofer then, Joe. You start off with something you like, and then give me something that you're concerned about. How about that?
Well, because I will address what Patricia and Laura referenced earlier, their antipathy towards the single investigator model, which I would agree with for public institutions of higher ed. That's, of course, where I spent the vast majority of my career and the like. But who doesn't agree? All the United States Circuit Courts of Appeal, and all but one district judge who was overturned in terms of private institutions of higher education. The American Bar Association, the Foundation for Individual Rights in Education, the New York Times, you name it, we could find private organizations, for-profit, not-for-profit, who use what would be called, in this context, a single investigator model, right? I'm sure there is no hearing panel at FIRE that hears all these cases and provides 2020 type regulations, and that's fine under Title VII, and you could find mountains and mountains of case law saying that that's okay. And all the circuit courts, except for the Sixth Circuit, have even said that that would work in the area of public higher ed. I'm not 100% sure it would, and there's certainly some other case law in the First Circuit that says you have to have some type of hearing, and I think that's generally the way the courts would go. I think that's the way the Supreme Court would treat it now. But the idea of moving back, which the department did in these 2022 proposed regulations, to a Matthews versus Eldridge style analysis of administrative law, right? Using those factors and allowing each institution, private, public, for-profit, not-for-profit, all the different types of various sizes, various resources and the like, to use that to drive their policy, I think overall is a positive. What didn't I like? Patricia mentioned it earlier, and I'll just put a bit more of an emphasis on it. This really odd, almost unheard of requirement that if somebody did not submit, the department's word, submit to cross-examination, which I think is a very interesting word to use. If somebody did not submit to cross-examination, no prior statement of theirs could be used for any purposes, which I thought was weird from the reporting individual side of the House, and I thought was unbelievably weird from the respondent side of the House, because many folks that colleagues like Patricia would represent also could face criminal charges. So they might say, no, I don't want to participate in this, I don't want to be subjected to submit to cross-examination by someone like Laura, because I don't want to say anything that could be used against me in criminal court. Therefore, none of their statements ever could be used. That was very weird. The Massachusetts District Court said no go and vacated that part. And yet this department brought back much of it, which boggles the mind.
Particularly surprising, given since after that district court ruling, we received an update from the department saying we will cease.
Don't use it.
Yeah, that's right.
So why did it show back up? I cannot figure it out. There was probably a good amount of commentary on it, but that's something that I saw that I was pretty disappointed in.
All right, well, excellent. I'm going to freeze us here, folks. I do want to make sure that folks who have shown up today have their questions answered. So feel free to jump in here. We have a question from an attendee who asks, do you feel the new regulations create too much of a scope for Title IX? I think, Joe, you reference it's 37 words, and we've heard from both Joe and Laura the kind of static interpretation for better part of 4 decades. What do you think now? Is the scope, so to speak, become too broad? Anybody wants to weigh in, feel free to go for it. Laura.
I mean, it is doing a lot of work, but it is a broad law, and it has a broad protected class, and it's only 37 words, and courts have interpreted it for decades. Like, it's a big law. There's a reason there's experts in this area. That said, I commented before, and I'll be brief here, people were trying to use it as if it was a due process mechanism as well for those who are accused. We already have constitutional due process. We already have that at the state level as well, often state constitution level due process. And then we have private schools who don't have due process. They just have, other requirements. So I think Title IX has been misused by the previous administration to do work it is not intended to do. But that said, a lot of the other stuff, coverage of LGBTQ students, pregnant students, all this around sex and gender identity, sexual orientation, I mean, that is the law. That is a landscape. And if it wasn't such a big cultural war politically, right, maybe it wouldn't be used so much. But we have a lot of battles going on at the state level.
It's necessarily broad, in other words. Yeah, thank you, Laura. Patricia and Joe, if you want to get in on that, otherwise we'll keep going here. All right. How about this? I have a question about informal resolutions. An attendee asked, at our school, the use of the informal resolution has been a very good option for students to resolve the matter in a way they want. We've used it for all types of cases, including reported sexual assaults. Can you speak to using this process across the board on all types of cases involving Title IX cases? Joe, if a client came to you about discussing the value of informal resolution, what's your take?
Well, I think it depends a bit on the institution, on its own culture and mission, and what other rules it is under. But certainly, my work has been around providing the parties to these cases with as much agency as they can. And there are folks who have been subjected to harassment or violence who, for various reasons, do not want to go through a formal process, just like there are folks who don't want to go to law enforcement. An undocumented student will have a very different experience with going to law enforcement than a student who grew up 3 blocks away from their educational institution. And so having the ability to respect that and provide more agency to the students going through the process is good. My only fear with informal resolution is that some folks have done a 1-hour webinar on restorative justice, and they say, well, okay, I guess now I'm an expert on restorative justice. And, for the same reason that if I needed a, cardiac surgery, I wouldn't look for someone who'd done an hour or, well, I've watched, Nurse Jackie every season. So I guess I'm ready to do your open heart surgery. I would hope for, again, more professionalism, more expertise among the folks who are engaging in an informal process.
Very good. Thanks. Patricia, Laura, any thoughts on informal resolution processes, their harm or value?
I will just say it depends on who's delivering the services in terms of the support for the parties going through it. I don't like some schools where Title IX coordinators get involved, and it should be somebody who has training. And just like anything in this realm, if you have people who are well trained and professional, generally things go right. It's just that there is so much burden on all of the different aspects, the Title IX coordinator, investigators, that what they're being asked to do is so monumental that not everybody is as good at it as we all would like them to be.
My only comment is that the previous regulations, I actually liked that they required a formal complaint before informal was given as an option to ensure record keeping. Because I have definitely seen cases as an expert where there's volumes of records about an informal process, but you have no idea how it was used, who is in it. It's like this black hole of, well, that's where we pushed half our cases or 80% of our cases. And we can't have that. Schools have swept violence under the rug. We know that happens, especially when it's against professors and other, high profile people. So we need to still have that careful record keeping. I think there should still be a complaint and the option at any point for a formal complaint to occur. And a lot of that has been kept, but it would just the requirement around the formal complaint first.
Yeah, go ahead, Patricia.
I have a case right now where this is sort of the law of unintended consequences. A situation where a student wanted restorative justice, a very bad ending to a relationship, a lot of bad stuff back and forth between both parties, and was told by the university, you must file a formal complaint in order to access this sort of informal restorative justice process. And so in other words, written complaint, very formal. And instead of leading to, well, let's all, work on this, the student who got, and it was a female student who got the complaint, now has a complaint pending against her in a relationship where there was intimate partner violence. And if it could have just been sort of an oral request, as opposed to, it threw gasoline on the fire. So I'm on the fence about a written complaint, but I do understand the need for both understanding the scope of what's being resolved as well as record keeping, but it can be problematic sometimes.
Yeah, that speaks to the difficulty and the fact-intensive nature of so many of these cases. We have a question. Can you speak to the real issue of a student wanting to use a witness as also their advisor? Thoughts there? Witnesses as advisors throughout the process.
The department generally has allowed a prohibition on that. That's not really a controversial issue, because generally speaking, at least under the Clery Act, you can't limit who is the advisor. But that has been, I think, universally accepted as appropriate. Someone cannot both be a witness and an advisor.
Very good. We have a fascinating question here from J. Morgan Levy, who writes, I work with many Title IX coordinators who are really, all caps, really burned out, primarily by being personally named in lawsuits and being understaffed and under-resourced. Do you think there's anything an amendment to the regulations could do to help, perhaps provide immunity from suit, require institutions to contribute X amount of funds to resource prevention work? Joe, I'm going to swing this one over to you as somebody who works closely with schools. What are you seeing in terms of Title IX coordinators who are riding this pendulum? And what's the impact, and what, if anything, can be done to help?
Yeah, so Morgan's 100% correct. Our Title IX coordinators are burning out. They are asked to do too much with not enough resources and not enough time. This is something I've spent my career working on. I don't believe there's anything in the regulations that can change to do that, but there are changes that institutions can make. I work with institutions that have prioritized this and have put appropriate funding to it, and consequently have fewer pieces of litigation and fewer complaints, but they also, more importantly, have better outcomes for their students. So many Title IX coordinators are simply Sisyphus pushing the rock up the mountain, where they can't think about how do they really get towards giving students better access to civil rights under a now half-century-old civil rights law. They're just trying to keep up with their email inbox. They're just trying to keep up with the cases in front of them. And unfortunately, we do not have a uniform approach towards appropriately funding this office and these needs and professionalizing it and giving folks the access to the training and the resources and the guidance and the thoughtful approaches that many of our laboratory institutions and our laboratory states are really creating. So the question is exactly right. I don't sense there's anything in the regulations. The regulations themselves certainly have raised the acknowledgement of this as an issue, but until institutions and state legislatures that fund many public and in some states private institutions in this work, until they really step up, I don't, unfortunately, see a change there.
Boy, we're getting all these good questions. Oh, go ahead, Laura, please.
I was just going to weigh in quickly. Despite being a lawyer and having a career around filing lawsuits, I agree that we should not have all these lawsuits. This is a reflection on the politics that is being played rather than the practicality that needs to be centered. And if we had minimal regulations, we could be guaranteeing more progress on the actual effectiveness, because campuses can consider unique issues for their campus, for their state, under other additional laws beyond Title IX. And it's really a call to the department, lessen the regulations, because the more regulations there are, the more disputes, but the more fights, and it won't slow down. And I even want it to slow down for schools, because I want them to get this right. And it's more important for the actual lives of students to get this right than it is for the political battles to be won.
That's right. Well, we had a comment to that effect from an anonymous attendee who says students don't care about the politics; they care about being heard. And I think that's what you're reflecting there, Laura. Patricia, do you want to get on this? Because otherwise we've got two last great questions.
Go for the last two. Great. Whatever they are, let's go for it.
Okay, let's see. Here we have a question. What stats on the races, ethnicities of respondent students has the government maintained, and what role does or should race play when considering the due process to be afforded respondents? As an attorney who represents many student respondents, Patricia, I'd be curious for your thoughts on that one.
I have no idea what stats are kept by the government, if any, and maybe somebody knows the answer to that. I will say that I don't think it would surprise anybody that some of the least resourced responding students are students of color, whether they are male or female, mostly male. But at least and I've represented hundreds of students, and we do always have a pro bono part of our practice. And oftentimes we find the students most in need of pro bono services are students of color. I don't know if there are more complaints made against them in the Title IX world, but I do think there are many disadvantages to anybody who is poorly resourced. And one of the problems with how voluminous these regulations are and what they're going to require to be put in place at any college or university is for any student to pick up the regulations or to pick up the policies at their schools based on these regulations and think they can figure their way through this, is going to be surprised. I think it's almost impossible without having a good advisor, whether it's an attorney or somebody trained within the university.
And a quick comment on that. So statistics, keeping statistics at the campus level, there is no requirement that I know of, but the Campus Accountability and Safety Act, which is before Congress, is trying to create that mechanism. And that's been proposed since 2014. I think there's flaws with that legislation, but the idea of having more data at the campus level of what are happening with complaints would be very beneficial and could perhaps be used towards racial equity purposes.
All right, thank you. I'm going to have time for one more, and then I want to just ask for closing thoughts, be respectful of our panelists' time here. Mark Addison asks, what possible challenges do you foresee for institutions regarding provisions for pregnant students, including trans people capable of becoming pregnant in the Nprm? Joe, you were talking about some of these issues earlier, the impact of the regulations here. I'd be curious, and I think, Laura, you also mentioned pregnancy provisions here, so either of you, please jump in.
Yeah, well, the regs came out the day before the decision in Dobbs that, as everyone knows, changed the landscape around access to abortion in many states in which K-12 and higher education institutions exist. The regulations cover not discriminating, and this is long-standing regulations for pregnancy and termination of pregnancy and some other areas around pregnancy. And so we are going to have fairly quickly a meet between state laws that prohibit abortion, prohibit termination, and also that will advance folks who report termination, providing them potentially with bounties that they can seek through litigation and the like, and the requirement that institutions somehow treat folks equitably on the basis of sex, including termination of pregnancy. For many institutions, they are going to have to maintain records. Laura and Patricia talked about this earlier, and will those records be accessible? And how will they be used in those litigation? Will they be used to punish students who have had to seek termination or obtain termination, whether in that state or externally to that state? This is going to be a massive area of potential challenges and potential harm for students, or unsurety about what harm they would face.
Go ahead.
And my understanding is on CNN earlier today, President Biden was making comments about using Title IX as part of this ongoing debate around abortion access. So for the comment before of like, is Title IX doing too much? Well, we just had a whole new thing added. And so it is being used as a tool for so many disputes that are happening politically.
There you go. I will just close with a quick, phrase. What's coming next? Kind of a crystal ball look. I would love to see all of you soon, but I hope we're not talking about this again 2 years from now. We shall see. Patricia, let's start with you. What's coming? What's in the future here? What can we expect?
I think very little change to the proposed regs and just more litigation, both challenging the regs that will be put in place, plus students who feel that the regulations that are then put in place have led to unfair, inadequate processes.
Gotcha. Thank you, Patricia. Joseph.
Less spoken about is a new law called the CHIPS Act, which includes $32 million+ potentially addressing sexual harassment in STEM. And I think we're going to see more approaches outside of Title IX addressing interventions and prevention before these crimes and violence occur. So in addition to agreeing with Patricia that we will see final regulations, we will probably see much more discussion, legislation, litigation, and the like. We may also see advances towards efforts to prevent these crimes before they occur.
Very good, Joe. Thank you. And Laura, we'll give you the last word here.
So people may know there was a Supreme Court decision recently in Cummings in April 2022 that has gutted a lot of arguments around damages being available for any civil right, including Title IX. I think we're going to see a massive influx in the Department of Ed being expected to handle more complaints, to resolve more complaints. And I'm hoping that there will be a legislative solution to what the Supreme Court has done on civil rights under Cummings, so that we can still have an adequate legal process. But the battle that is happening is so much bigger than the regulatory level. It is overwhelming, and we're going to have to deal with that in the decades to come.
Well, thank you, Laura. Thank you, Joe. Thank you, Patricia. And thanks to all who have asked excellent questions. And thanks, Laura, for answering that last one we didn't get to online. It's 1:01 p.m. here on the East Coast. So for the ABA and the Administrative Law and Regulatory Practice section, specifically the Education Committee, my name is Will Creeley. Thank you so much for joining us. And thanks, folks, for all the expertise and the good questions. You have a great day. Bye, everybody.
Thank you.